32 of CA Foundation. Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Section number 4. Partnership is the relationship Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Part Persons who have entered into partnership with are called individually partners and collectively the firm, and the name under which their business is carried on is the firm name. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which their business is carried on is called the firm name. Elements of partnership: association of two or more persons. Partnership is an association of two or more persons. Only persons recognized by law can enter into partnership. Partnership is an association of two or more persons. Only persons recognized by law can enter into an agreement of partnership. Minor can't be a partner in a firm, but with the consent of all the partners, may be admitted to the benefits of partnership. Partnership firm, since it is not a person recognized in the eyes of law, can't be a partner. Maximum number of partners. Indian Partnership Act silent, but Section 464 of the Companies Act 2013 put a limit of 50 partners. Agreement. Partnership is the result of an agreement. There must be voluntary contractual agreement. It may be express or implied. It may be oral or in writing. Business. There must be some business. Includes every trade, occupation and profession. Motive of business is acquisition of gains. No partnership. If no intention to carry business and to share profits. Agreement to share profits. Sharing of profits is essential. No partnership where only one partner gets a whole profit, but sharing of losses is not essential. Any manner of profit sharing ratio is allowed in losses unless otherwise agreed. They must bond in their profit sharing ratio. Business carried on by all or any of them acting for all. There must should be a binding contract of mutual agency. This is cardinal principle of partnership. Act of one partner in the course of business is an act of all partners. Each partner is principal as well as the agent of for all other partners. Agent as he can bind other partners, and principal as he is bound by other partners. True test of partnership is mutual agency rather than the sharing of profits. No mutual agency, no partnership. In KD Kamath and Company, Supreme Court has held two essential conditions for partnership: sharing of profits as well as losses, and business must be carried on by all or any of them acting for all. If exclusive power and control by agreement is vested with one partner, these are not destructive of partnership theory if above two conditions are satisfied. True test of partnership. Section number 6. There was an agreement between all the persons concerned. Section number 5. There was an agreement between all the persons concerned. Section number 5. There was an agreement between all the persons concerned. Section number 5. Agreement slash relationship is created by an agreement. Agreement slash relationship is created by an agreement and not by status. Agreement slash relationship is created by an agreement, not by a relation, not by the status. Member of HUF or Burmese Buddhist husband and wife are not partners in business. Agreement was to share the profits of a business. Agreement was to share the profits of a business. Sharing of profits or of gross returns arising from property by persons holding a joint or common interest in that property does not of itself make such persons partners. The receipt of profits or payment contingent upon earning does not make itself the following persons as partners of the business. By a lender of money to persons engaged or about to engage in business, by a servant or agent as remuneration, by a widow or child of a deceased partner as annuity, or by a previous owner or a part owner of business as consideration for the sale of goodwill or share thereof. Sharing of profits is an essential element to constitute a partnership, but it is only a prima facie evidence and not a conclusive evidence. When there is no specific agreement as to determination of partnership, refer section number 6. All relevant facts, such as written or verbal agreement, real intention, conduct of the parties, other surrounding circumstances, etc., are to be considered while deciding the partnership. All relevant facts, such as written or verbal agreement, real intention, conduct of the parties, other surrounding circumstances, etc., are to be considered while deciding the partnership. Business was carried on by all or any of them acting for all. Point 5 of elements. In Santiranjan Das Gupta versus Desiran Murzamul, Supreme Court looked to conclude no partnership. Parties have not retained any record of terms and conditions of partnership. Partnership business has maintained no accounts of its own, which would be open to inspection. No account of the partnership was opened with any bank. No written intimation was conveyed to Deputy Director of Procurement WRT New Partnership. Partnership versus Joint Stock Company. Legal status, agency, profit distribution, extent of liability, property, transfer of shares, management, registration, winding up, number of members, duration of existence. Let's learn it. Legal status, agency. Legal status, agency. Profit distribution, extent of liability. Legal status, agency, profit distribution, extent of liability. Property, transfer of shares. Legal status, agency. Legal status, agency, existence of extent of liability, profit distribution, property, and transfer of shares. Let's learn it again. कितने मेंबर हैं, कितने टाइम तक काम करेंगे, कब वाइंड अप करेंगे, कैसे उन्होंने रजिस्ट्रेशन करी, कैसे उनकी मैनेजमेंट चल रही है, उनकी कंपनी में शेयर्स हम एक दूसरे को दे सकते हैं, नहीं दे सकते, प्रॉपर्टी दे सकते हैं, नहीं दे सकते, लाइबिलिटी चलो उनकी कितनी आएगी, प्रॉफिट कैसे डिस्ट्रीब्यूट करेंगे, उसके उनके अंदर एजेंसी तो होती है, हमें पता ही है, और लीगल स्टेटस बाकी एक। चलो अब एक बार याद करते हैं। ड्यूरेशन ऑफ एग्जिस्टेंस, कितने मेंबर होंगे, नंबर ऑफ मेंबर्स, रजिस्ट्रेशन कैसे कराई होगी उन्होंने, वाइंडिंग अप, मैनेजमेंट, ट्रांसफर ऑफ शेयर्स, प्रॉपर्टी, एक्सटेंट ऑफ लाइबिलिटी, प्रॉफिट डिस्ट्रीब्यूशन, उन्होंने एजेंसी भी होगी, लीगल स्टेटस। पार्टनरशिप वर्सेस क्लब, इसके अंदर 4 पॉइंट है। डेफिनेशन, रिलेशनशिप, इंटरेस्ट इन प्रॉपर्टी एंड डिसोल्यूशन। डेफिनेशन, लीगल स्टेटस था ही नहीं कुछ। डेफिनेशन, रिलेशनशिप, डेफिनेशन रिलेशनशिप, उनके अंदर डिसोल्यूशन कैसे होगा, डेफिनेशन रिलेशनशिप, डिसोल्यूशन, इंटरेस्ट इन प्रॉपर्टी उनका कैसा होगा। पार्टनरशिप वर्सेस हिंदू अनडिवाइडेड फैमिली। उनका मोड ऑफ क्रिएशन कैसा होगा, डेथ ऑफ मेंबर कैसा होगा, मैनेजमेंट कैसी होगी, वो उनके पास अथॉरिटी होगी नहीं होगी, लाइबिलिटी उनकी कहाँ तक जाएगी, क्लोजर ऑफ अकाउंट्स उनके अंदर नहीं होगा, गवर्निंग लॉ, कैपेसिटी ऑफ माइनर, कंटिन्यूटी, नंबर ऑफ मेंबर्स शेयर इन द बिजनेस। चलो यार एक बार वापस बोलते हैं। मोड ऑफ क्रिएशन, डेथ ऑफ मेंबर, management, authority to bind, liability, closure of accounts, governing law, of minor, continuity, number of members, share in the business. एक और बार, mode of creation, death of member, management, authority to bind, liability, closure of accounts, governing law, capacity of minor, continuity, number of members, share in the business. एक और बार, mode of creation, death of member, management, authority to bind, liability, closure of accounts, governing law, capacity of minor, continuity, number of members, share in the business. चलो बाकी, पार्टनरशिप वर्सेस को ओनरशिप, फॉर्मेशन, implied agency, nature of interest, transfer of interest. Formation, implied agency, transfer of interest, nature of interest. Partnership versus association, meaning and example. Partnership versus association में meaning and example. Kinds of partnership. Partnership at will. Section number 7. No fixed period has been agreed upon for the duration of the partnership, and no provision made as to the determination of the partnership. If there is an agreement either for duration determination, that then it is not a partnership at will. Where a partnership entered into for a fixed term is continued after the expiry of such term, it is to be treated as having become a partnership at will. A partnership at will may be dissolved by any partner by giving notice in writing to all the other partners of his intention to dissolve the same. Partnership for a fixed period. Provision is made by contract for duration of the partnership created by a particular period of time ends after expiry of the such period. हाँ पढ़ दे, एक और बार पढ़ते हैं, ठीक है। पार्टनरशिप एट विल, section number 7. No fixed period has been agreed upon for the duration of the partnership, and no provision made as to the determination of the partnership. If there is an agreement either for duration or determination, then it is not a partnership at will. Where a partnership entered into for a fixed term is continued after the expiry of such term, it is to be treated as having become a partnership at will. A partnership at will may be dissolved by any partner by giving notice in writing to all the other partners of his intention to dissolve the same. Next point, partnership for a fixed period. Provision is made by contract for duration of partnership created for a particular period of time ends after expiry of the fixed period. Next point, particular partnership. Organized for the prosecution of single adventure or conduct of a continuation business. Organized for the conduct of a single adventure or conduct of a continuous business is particular partnership. Person become a partner with another person in any particular adventure or undertaking subject to any agreement dissolved by the completion of the adventure or undertaking. General partnership constituted WRT, the business in general, different from the particular partnership and LLP, means limited liability partnership. What is general partnership? Constituted WRT, the business in general, business in not known, different from particular partnership and limited liability partnership. Liability of partner in particular partnership extends to that particular adventure, but not in case of general partnership. Partnership deed. Partnership is the result of an agreement. No formality is required, maybe in writing or verbal, but desirable in writing to avoid the disputes. contains various terms and conditions so as to the contain various terms and conditions as to the relation of partners to each other is called partnership deed. Should be drafted with care and stamped according to the Stamp Act 1899. If immovable property, instrument must be in writing, stamped and registered. Contain the following informations: name of the partnership firm, name of all the partners, nature and place of business of firm, date of commencement of partnership, duration of the partnership firm, capital contribution of each partner, profit sharing ratio of the partners, admission and retirement of a partner, rates of interest on capital drawing and loans, provision for settlement of accounts in case of dissolution of firm, provision for salaries or commissions payable to the partners if any, provisions for expulsion of a partner in case of gross breach of duty or fraud. Not a partnership may add or delete any provision according to the needs of the firm. Partnership deed. Partnership is the result of an agreement. No formality is required, may be in writing or verbal, but desirable in writing to avoid the disputes. Contains various terms and conditions so as to the relation of partners to each other is called a partnership deed. Should be drafted with care and stamped according to the Stamp Act 1899. If immovable property, instrument must be in writing, stamped and registered. Contain the following information: name of the partnership firm, name of all the partners, nature and place of firm, date and commencement of partnership, duration of the partnership firm, capital contribution of each partner, profit sharing ratio of the partners, admission and retirement of a partner, rates of interest on capital drawings and loans, provisions for settlement of accounts in the case of dissolution of the firm, provisions for salaries or commission payable to the partners, if any, provisions for expulsion of a partner in case of gross breach of duty or fraud. A partnership firm may add or delete any provision according to the needs of the partnership firm. Types of partners: acts as an active, actual, or ostensible partner. Active or actual or ostensible partner acts as an agent of other partners for all acts done in the ordinary course of business. On retirement, he must give a public notice in order to absolve himself of liabilities. Sleeping or dormant partner. Sleeping or dormant partner share profit and losses but are liable to third parties. Also, no public notice required on retirement. Nominal partner. Nominal partner lends his name to the firm without having any real interest in it. Neither invests nor takes any part in the business, but are liable to third parties for all acts. Partner in profits only. Entitled to share the profits only without being liable for the losses. Also liable to third parties for all the acts. Incoming partners. Admitted as a partner into an already existing firm with the consent of all the existing partners. Remains liable to third parties for all the acts of firm until public notice is given of his retirement. Outgoing partners. Partner who leaves the firm in which the rest of the partners continue to carry on business remains liable to third parties for all acts of firm until public notice is given of his retirement. Partner by holding out or partnership by estoppel. Section number 28. Partner by holding out or partnership by estoppel. Section number 28. Where a man holds himself out as a partner or allows others to do it, he is then stopped from denying the character he has assumed and upon the faith of which creditors may be presumed to have acted. एक और बार रीड करते हैं लाइन. Where a man holds himself out as a partner or allows others to do it, he is then stopped from denying the character he has assumed and upon the faith of which creditors may be presumed to have acted. A person may himself, by his words or conduct, have induced others to believe that he is partner, or he may have allowed others to represent him as a partner. Only the person to whom the representation has been made and who has acted thereon that has right to enforce liability arising out of holding out. It is not necessary to show that purpose of representation was a fraudulent intention. Section number 28 is also applicable to a former partner who has retired from the firm without giving proper public notice of his retirement. In such cases, a person who, even subsequent to his retirement, give credit to the firm on the belief that he was a partner will be entitled to hold him liable. ये आगे इन लाइनें वापस करते हैं. A person may himself by his words or conduct may have induced others to believe that he is a partner, or he may have allowed others to represent him as a partner. Only the person to whom the representation has been made and who has acted thereon that he has right to enforce liability arising out of holding out. It is not necessary to show that purpose of representation was a fraudulent intention. Section number 28 is also applicable to a former partner who has retired from the firm without giving proper public notice of his retirement. In such cases, a partner who, even subsequent to his retirement, give credit to the firm on the belief that he was a partner, he will be entitled to hold him liable. Chapter number 4, Unit number 2, Relations of Partners. Relations of partners to one another. General duties of partners. Section number 9. Carry business on common advantage. Render full information. Utmost good faith in dealings. Render accounts to each other kept by one prima facie proper person to explain. Second point. Duty to indemnify for loss caused by fraud. Section number 10. Make good the loss sustained by firm. Amount bought divided between partners. If fraud, co-partners can throw whole consequences upon him. Rights and duties by contract. Section number 11. Subject to the provisions of this act, determined by the contract, valid by consent of all the partners. Conduct of the business. Section number 12. Take part in the conduct of the business. Attend diligently in the conduct of business. Right to be consulted. Difference majority but not change in nature of business. But no change in nature of business without the consent of all. Access to books of accounts allowed to all. Right of legal representative. एक और बार रीड करते हैं. Conduct of the business. Section number 12. Take part in the conduct of the business. Attended diligently in the conduct of business. Right to be consulted. Difference majority but no change in the nature of business without the consent of all. Access to books of accounts allowed to all. Right of legal representative /H/A. Assess, inspect, take copies of books of accounts. Mutual rights and duties. Section number 13. First point. Right to remuneration. No remuneration for taking part is business subject to any agreement or dealings. But if customary to pay Remuneration partner can claim it even without agreement. Right to share profits. If no agreement is made, partners will share profits and loss equally. If agreement made, it will prevail. Also, there is no connection between profit sharing ratio and capital contribution. Third point, interest on capital. Following elements are required for interest on capital: express agreement or practice of partnership, trade custom, statutory provision, interest on advances. Claim interest at the rate 6% per annum on amount paid in addition to capital contribution. It will keep running even after dissolution and up to the date of payment. For fifth point, right to be indemnified in respect of payments made and liabilities incurred in ordinary conduct and emergency. Right to indemnify the firm for loss caused by it by willful misconduct of the business of the firm. Partnership property, section number 14. The property which is deemed as belonging to the firm in absence of any contract. All property rights and interest which partners may have brought into the common stock as their contribution to the common business. All the property rights and interest acquired or purchased by or for the firm, goodwill of the business. Note whether it is property of firm or not will depend upon the intention of the partners. Partners may by agreement convert exclusive property into a partnership property. About goodwill. It is the value of reputation of a business house in respect of profits expected in future over and above the normal level of profits. Partnership firm is dissolved. Every partner has a right to have the goodwill of business sold. It can be sold separately or along with the other properties of the firm. Agreement in restraint of trade in case of sale of goodwill is valid if the restrictions imposed are reasonable. Application of property of the firm. Section number 15. Property of the firm shall be held and used exclusively for the purpose of the firm. In partnership, there is a community of interest which all the partners take in the property. Partner does not have any proprietary interest in the assets of the firm. Every partner of the firm has a right see that all the assets of the partnership are applicable are applied to and used for the purpose of the partnership business. Personal profit earned by partners, section number 16. If a partner derives any profit for himself from any transaction of the firm or from the use of the property or business connection of firm or the firm name, he shall account for that profit and pay it to the firm subject to contract. If a partner carries on any business subject if any partner carries on any business of the same nature that and if a partner carries on any business of the same nature as and competing with that of the firm, he shall account for and pay to the firm all profits made by him in that business. Rights and duties of partners have a change in the firm. Rights and duties of partners after a change in the firm, section number 17. According to section number 17, subject to contract between the partners. After a change in the firm, after the expiry of the term of the firm, where additional undertakings are carried out, the rights and duties will be the same as those as it was in its previous operations. Relation of partners to third parties. Partner to be an agent of firm, section number 18. Character of both principal and agent. Difference between mere agent and partner. Agent is community of interest. Agent only for the purpose of the business. Implied authority of partner as agent of the firm, section number 19. Act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Authority to bind the firm is called implied authority. In the absence of any usage or custom of trade to the contrary, the implied authority of the partner does not empower. Submit a dispute relating to the business or arbitration. Open a banking account on behalf of the firm in his own name. Compromise or relinquish any claim or portion of a claim by the firm. Withdraw a suit or proceedings filed on behalf of the firm. Admit an liability in suit or proceedings against the firm. Acquire immovable property on behalf of the firm. Transfer immovable property belonging to the firm and enter into partnership on behalf of the firm. एक और बार पढ़ते हैं इसको. Implied authority of partner as agent of the firm. Section number 19. Act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Authority to bind the firm is called implied authority. In the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower. Submit a dispute relating to the business or arbitration. Submit a banking account on behalf of the firm in his own name. Compromise or relinquish any claim or portion of a claim by the firm. Withdraw a suit or proceedings filed on behalf of the firm. Admit an liability in a suit or proceedings against the firm. Acquire immovable property on behalf of the firm. Transfer immovable property belonging to the firm and enter into partnership on behalf of the firm. Mode of doing act to bind the firm. Section number 22. In order to bind a firm, the act or instrument executed should be executed in the firm name with an intention to bind the firm. Implied authority have following restrictions. Act done must be within scope of authority and must and relate to usual business of firm. Act is done for normal conduct of business. Act act to be done in the name of the firm with an intention to bind the firm. If partnership be of a general commercial nature, he may pledge or sell the partnership property, he may buy goods on account of the partnership, he may borrow money, contract debts, and pay debts on accounts of the partnership, he may draw, make, sign, endorse, transfer, negotiate, and procure to the discounting promissory notes, bills of exchange, checks, and other negotiable instrument in the name and on account of the partnership. Extension and restriction of partners' implied authority. Section number 20. Restrictions imposed on the implied authority of a partner by agreement shall be effective against a third party when third parties knows about it and third party does not know that he is dealing with the partner in the firm. Any one partner or even a majority of the partners can't restrict or extend the implied authority. Consent of all partners is required for the restrictions. Green tick question. Extension and restrictions of partners' implied authority. Section number 20. Restrictions imposed on the implied authority of a partner by agreement shall be effective against a third party when third party knows about it and third party does not know that he is dealing with a partner in the firm. Any one partner or even a majority of the partners can't restrict or extend the implied authority. Consent of all partners is required for the extension. Restrictions. Partners' authority in an emergency. Section number 21. A partner has authority in an emergency to do all such acts for the business of protecting the firm from loss as would be done by a person of ordinary prudence in his own case acting under similar circumstances, and such acts bind the firm. Effect of admission by a partner. Section number 23. Partners as agents can make binding admissions but only in the ordinary course of business. Admission will not bind the firm if the authority is limited and other parties knows about it. Red tick questions. Caution मतलब effect of notice to acting partner. Section number 24. The notice to a partner who habitually acts in the business of the firm relating to affairs of the firm operates as the notice to the firm. Notice to one is equivalent to notice to all exception fraud committed by all with the consent of that partner. Notice must be actual and not constructive, must be received by a working partner and not by a sleeping partner. Notice must relate to firm's business, then only it will constitute notice to firm. Liability to third parties. Section number 25 to 27. Liability of partner for acts of the firm. Section number 25. Partners are jointly and severally liable for all acts which comes under the scope of their express or implied authority because the act is done towards business of firm. Act means rights enforceable by or against the firm. Act to be enforceable must have been done while he was a partner. Liability of firm for wrongful acts of a partner. Section number 26. Firm is liable to the same extent as partner for any loss or injury caused to the third party by the wrongful act of partner done in the ordinary course of business and within authority of partner. Method employed by partner in doing wrongful or unauthorized act would not affect the caution. All partners are liable to third party for loss or injury caused to him by the act of any partner acting in ordinary prudence. Heredity question. Liability of firm for misapplication by partner. Section number 27. If partner acts within the authority and received money or property of third party and misapplies it, not necessary that money should comes in its come in its custody, or if money or property comes into the custody of firm and misapplied by any partner, the firm will be liable in both the cases. If a receipt was not in the authority of partner, it can't be said that money received by firm, hence firm not liable unless money comes into the firm's custody or control. Right of transferees, rights of transfer of a partner's interest. Section number 29. A share in a partnership is transferable like any other property, but as the partnership relationship is based on mutual confidence, the assignee of a partner's interest by sale, mortgage, or otherwise can't enjoy the same rights and privileges as the original partner. Rights of transfer of a partner's interest. Section number 29. Red tick है इसमें. A share in a partnership is transferable like any other property, but as the partnership relationship is based on mutual confidence, the assignee of a partner's interest by sale, mortgage, or otherwise can't enjoy the same and privileges as the original partner. Rights of such a transferee. During the continuance of partnership, transferee is only entitled to receive a share of profit and he is bound to accept it, can't challenge it. Such transfer is not entitled to interfere with the conduct of business, require accounts and inspect books. On dissolution of firm or retirement of transferring partner, transfer is entitled to receive the share of assets of firm to which transferring partners were entitled for the purpose of ascertaining share entitled to accounts from the deed. Note: partner can transfer its share but after only after approval from all the partners. Minors admitted to the benefits of partnership. Section number 30. Green tick. Minor can't be bound by contract because a minor's contract is void. Minor can't become partner in partnership firm as he is incompetent to contract, but he can be admitted to the benefits of partnership with the consent of all the partners under Section 30. Rights of minor. Rights Rights of a minor. Agreed share of profit, assess, inspect and copy of accounts of the firm, sue the partners for accounts or payment of his share but only when he is severing his connection with the firm. On majority may within 6 months elect to become a partner or not to become. If partner if become a partner entitled to share as earlier, if does not, his share is not liable for any act of the firm after the public notice. Liabilities of minor before majority confined only to the extent of his share of profits and property. No personal property for debts of the firm can't declare as insolvent. But if firm is declared insolvent, then minors shares vest with the official assignee. Receiver can claim from official assignee. Liabilities of minor after majority. Within 6 months of majority or after knowledge that he is entitled to the benefits of partnership, whichever date is later, decide whether to remain partner or leave the firm. If became partner willfully or failure to give public notice, personally liable to third parties for all acts of firm, since he was admitted to the benefits of partnership and his share remains the same as earlier. Not to become partner, rights and liabilities remain same up to the date of public notice. Failure to give it within 6 months will make minor liable as partner. Share not liable after public notice can sue partners for shares. Not notice to register on becoming partner or not to become partner is mandatory. Legal consequences of a partner coming in and going out. Section number 31 to 35. Any change, admission, retirement, expulsion, insolvency, etc. in relationship of a partner will result in reconstitution of firm. Introduction of a partner, section number 31. No new partners can be introduced into a firm without the consent of all existing partners. सेक्शन नंबर 31 तो हमने पढ़ा इंट्रोडक्शन ऑफ अ पार्टनर. No new partners can be introduced into a firm without the consent of all existing partners. Rights and liabilities of new partner. Liabilities ordinarily commence from the date when he is admitted, unless he agrees to be liable for obligations incurred by the firm prior to the date. The new firm may agree to assume liability for the existing debts of the old firm, and creditors may agree to accept the new firm as their debtor and discharge the old partners. The creditor's consent is necessary in every case to make the transaction operative. Novation is the technical term in a contract for substituted liability, but a mere agreement amongst partners can't operate as novation. Partnership of two partners automatically dissolved by death of one. Section number 31 will not apply. Retirement of partner, section number 32. A partner may retire with the consent of all the other partners by express agreement, by giving notice in writing to all other partners of his intention to retire in case of partnership at will. Retiring partner may be discharged from any liability to any third party for acts of the firm done before his retirement by an agreement made by him with such a third party on the with the such third party and the partners of the reconstituted firm. Partners continue to be liable to third parties before retirement until public notice is given. Not liable if a third party deals with the firm without knowing that he was a partner. In the event of retirement, partnership business will not come to an end. Supreme Court in Vishnu Chandra versus Chandika Prasad. Expulsion of a partner, section number 33. If all these conditions are not present, green tick. Expulsion of a partner, section number 33. If all these conditions are not present, the expulsion is not deemed to be in bona fide interest. Power of expulsion must have existed in the contract between the partners. The power has been exercised by a majority of the partners and it has been exercised in good faith. The test of good faith is as required under section number 33 subsection 1 includes three things. Expulsion must be in the interest of the partnership. Expulsion Partner to be expelled is served with the notice. He is given an opportunity of being heard. If a partner is otherwise expelled, the expulsion is null and void. Note: expulsion doesn't result in dissolution of partnership. Neither invalid expulsion puts an end to the partnership, even if the partnership at will. It will be deemed to continue as before. Insolvency of a partner, section number 34. Where a partner in a firm is adju- adjudicated as an insolvent, he ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is hereby dissolved. A state of a partner so adjudicated is not liable for any act of firm, and the firm is not liable for any act of the insolvent done after the date of order of adjudication is made. Effects of insolvency relic. Insolvent partner can't be continued as a partner. He will be ceased to be a partner from the date on which the order of adjudication is made. A state of insolvent partner is not liable for acts of the firm done after the date of order. Firm is for any act of the insolvent partner after the date of order. Ordinarily, insolvency of partner results in dissolution of firm, but the partners are competent to agree among themselves that the adjudication will not give rise to dissolution of firm. Granting liability of estate of deceased partner, section number 35. Ordinarily, the effect of the death of a partner is dissolution of the partnership, but partners are competent to agree that the death of one will not have the effect of dissolving. Estate of the deceased partner may be absolved from liability for the future obligations of the firm. It is not necessary to give any notice either to the public or the persons having dealings with the firm. No public notice required in case of death. Granting rights of outgoing partner to carry on competing business, section number 36. An outgoing partner may carry on business competing with that of the firm and he may advertise such business, but subject to contract to the contrary. He may not use the firm name, represent himself as carrying on the business of the firm, or solicit the customer of persons who were dealing with the firm before he ceased to be a partner. Agreement in restraint of trade valid if reasonable to make an agreement with the partners that on ceasing of partnership he will not carry on any similar business within a specified period or within specified local limits. Green tick. Rights of an outgoing partner in certain cases to share subsequent profits, section number 37. Where a partner dies or otherwise ceased to be a partner, then the remaining partners continue the business using the firm's property without settling accounts with the outgoing partner or their estate. The outgoing partner or his estate is entitled to either a share in the profits earned since their exit to the extent attributable to the use of their share in the property, or interest at 6% per annum on the amount of their share in the firm's property. However, if the continuing partners purchase the outgoing or deceased partner's interest and the option to do so is properly exercised, then the outgoing partners or their estate is not entitled to any further profits of or interest. Revocation of a continuing guarantee by change in firm, section number 38. A continuing guarantee given to a firm or to third party in respect of the transaction of a firm is so as revoked as to future transaction from the date of any change in the constitution of the firm in the absence of an agreement to the contrary. Chapter number 4, Indian Partnership Act. Unit number 3, Registration and Dissolution of a Firm. Registration of Firms. Section number 58, 59, 59A1. Application for registration, section number 58. Registration of a firm may be affected at any time by sending by post or delivering to registrar of the area in which any place of business is situated or proposed to be situated. A statement in the prescribed form and fee stating firm's name, place or principal place of business, names of other business places, date when each partner joined, full name and permanent address of partners, duration of the firm. Statements shall be signed and verified by all partners or by their agents as specially authorized. A firm name shall not contain any of the following words, namely crown, emperor, empress, empire, imperial, king, queen, royal, or words expressing or implying the sanction, approval, or patronage of government except when the state government signifies its consent to the use of such word as part of the firm name by order in writing. Registration of firm, section number 59. Registrar is certifies then record an entry of the statement in registrar of firms and file the statement, issue certificate of registration. Effective date registration is deemed to be completed as soon as an application in prescribed form, fee, and necessary details of partnership is delivered to registrar. Recording of an entry in the registrar of firms is a routine duty of registrar. Registration may also be effective even after a suit has been filed by the firm, but in that case, it is necessary to withdraw the suit first and then get the firm registered and then file a fresh suit. Late registration on payment of penalty. Section number 59A1. If the statement of any firm is not sent or delivered within the time specified, then firm may be registered on payment of penalty of 100 per year, 100 rupees per year of detail or a part of thereof to the registrar. Consequences of non-registration. Section number 69. Registration of firms is not compulsory as per Indian Partnership Act, yet the consequences or disabilities of non-registration have a persuasive pressure for the registration. Point number one, no suit in a civil court by firm or other co-partners against a third party. Can't bring any action against the third party for breach of contract entered unless the firm is registered and the persons are or suing are or shown in the registration of firms as partners. No relief to partners for set of claim. If an action is brought against the firm by a third party, neither the firm nor partner can claim any set of if the suit be valued for more than rupees 100. Aggrieved party can't bring legal action against other partner or the firm. Partner of an unregistered firm is precluded from bringing legal action against the firm or alleged partner have been a partner in the firm may sue for dissolution or for accounts and realization of his share when firm is dissolved. Fourth point, third party can sue the firm. Action can be brought against the third party by a third party. Exceptions. Non-registration of a firm does not, however, affect the following rights. Rights of third party to sue the firm or any partner. Right of partner to sue for dissolution or settlement of accounts or for realization of property. Power of an official assignees receivers of court to release the property of insolvent partners. Right to sue or claim a set of in if the value of suit does not exceed rupees 100 in value. Right to suit in right to suit and proceedings instituted by legal representatives or hires of the deceased partner of the firm for accounts of the firm or to realize the property of the firm extra note on filing on of suit. To file a suit, check if it must be instituted by or on behalf of the firm which had been registered and persons all suing had been shown as partner in the registrar of firms. No registration to registrar required for subsequent dealings in case business was carried on after death of one of the partners. In case of new partner admission, notify to registrar required, who shall make a record to the notice in the entry relating to the firm in the registrar of firms. Dissolution of firm, section number 39 to 47. As per section number 39, dissolution of partnership between all partners of a firm is called the dissolution of the firm. Difference between dissolution of firm and dissolution of partnership. Continuation of business, winding up, order of court, scope, final closure of books of accounts. Continuation of business, winding up, order of court, scope, and final closure of books of accounts. Last two pages pending. Mode of dissolution of court without court intervention or voluntary. Section number 40, dissolution by agreement. By consent of all or subject to the contract. Compulsory dissolution. Section number 41, all partners, all except one, insolvent. Any event making business unlawful does not affect lawful business. Happening of certain contingencies. Section number 42, expiry of fixed term, completion of adventure or undertaking, death of a partner, adjudication of a partner as insolvent, notice of partnership at will by any partner in writing, stating intention, date of dissolution mentioned, same date, date not mentioned, date of commencement of notice. With the court intervention, mode of dissolution of court. Insanity or unsound mind, temporary sickness is no permanent incapacity, may result from physical disability or illness, etc. Misconduct, effective prejudicially the carrying on business, not necessary that is related to business. Important is adverse effect on business. Persistent breach of agreement, willfully or persistent breach relating to management or conduct of or reasonable, not practical to carry on business. Cases, embezzlement, erroneous account holdings, more cash than allowed, holding more cash than allowed, refusal to show accounts, transfer of interest. Interest wholly transferred or charged just and equitable grounds, deadlock in management, partners are not taking, loss of substratum, gambling. Consequences of dissolution, section number 45 to 55. Liability for acts of partners done after dissolution, section number 45. Partners continue to be liable unless public notice is given, provided deceased partner estate adjudicated insolvent or who is not known to the person dealing with the firm's sleeping partner, not liable as no public notice required. Objective of notice, it seeks to protect third parties dealing with the firm and also to protect the partners of dissolved firm from liability towards the third parties. Rights of partners to have business wound up after dissolution, section number 46. Every partner or representative entitled to have property of firm to be applied in payment of debts and liabilities of firm and to have surplus distributed according to their rights. Continuing authority of partners for purposes of winding up, section number 47. After dissolution, authority of partner to bind the firm continues as necessary to wind up the affairs of the firm and to complete transactions begun but unfinished, provided firm not liable for adjudicated insolvent as and not affect liability of partner by estoppel. Mode of settlement of partnership accounts, section number 48. Following rules must subject to contract Losses including the deficiencies of capital, profits out of capital, partner individually if necessary in proportion of profit sharing ratio. Assets including deficiencies of capital, applied debt of the firm to third parties, to each partner due from him, from capital to each partner due to him on account of capital, residue if any to be divided by partner in proportion of profits, payment of firm debts and of separate debts when there are joint debts due from the firm and also separate debts due from any partner, property of firm, payment of the debts of firm surplus if any partners, separate debts, separate property of partner, payment of his separate debts surplus if any, payment of debts of the firm, and completed. Indian partnership.